which is an appropriate topic that we'll be discussing today as we begin to analyze today's very historic decision that furthers LGBTQ rights in the workplace. Thank you, Professor Whitehead. I guess let's just start off with the absolute basic. This decision seems to be pretty clear cut. Can you break down for our readers in a almost pedestrian fashion what this decision indicates?
Sure. So in 1964, the Congress passed the Civil Rights Act, which protects people from discrimination in the workplace. In part, it does a bunch of other things as well, but the relevant language is that people cannot be discriminated against, excuse me, on the basis of sex, on account of sex, right? So that word sex got inserted into the 1964 Civil Rights Act, which most people thought was a protection of women, and it certainly has been over the years. Today's ruling extends the same protections that women have in the workplace under federal law against discrimination to gays and lesbians and to transgender individuals.
How did the majority, which, and for our listeners, we're going to get into the fact of how the conservative side of the bench became split on this decision, but how did the majority opinion arrive at the answer that LGBTQ people are included within this 1964 definition of sex?
Sure. So so really it depends on whether you're going with a 1964 definition of sex and what that actually means. So the majority says that when you're interpreting a word in a statute, what you basically have to do is try to figure out, is the word clear on its face first? And if it's not clear on its face, then you may need some extra help. You may need to figure out what was the intent behind it, what was the historical understanding at the time. But the majority looks at the word sex and says, everyone knows what this word means, and it means biological sex. It means whether you're a man or a woman. So does that extend to your sexual preference? Does it extend to your sexual orientation? Does it extend to your gender identity? It may or may not, depending on the context, but in this context, in the context of employment discrimination, according to Justice Gorsuch's majority opinion, the only way that a person could be discriminated against on the basis of their sexual orientation or on the basis of their gender identity is by taking into account their biological sex. So for example, you have a gay man who comes in to apply for a job and is equally qualified with heterosexual guys who apply for the same job. And the employer finds out that the applicant is gay and denies that person employment. You could say it's because of his sexual orientation, but the only reason his sexual orientation matters is because he's a man who is attracted to other men because of his biological sex and because of the biological sex, obviously.
And the same could be extended for a trans woman. It's only because of her birth assigned gender
that's right
that even comes into account.
Right.
Now, what I find fascinating about this, so it was Justice Gorsuch who wrote the majority opinion. For those who don't know, Gorsuch wasn't a Trump appointee to the court and leans on the conservative side. We would obviously expect the liberal side to go with what they went with. Could you explain the conservative ideology that went behind supporting this majority opinion?
So conservatives, ever since I would say, late 1970s, early 1980s, have kind of coalesced around a very restrained understanding of the judicial role. Actually, it goes back even further, back to the Warren Court, to the 1960s. Conservatives have been arguing ever since then that the job of a judge is very narrow. And the job of a judge is not to be a legislator. It's not to say what the judge thinks should be the outcome, but simply to interpret the words of the law. So what Gorsuch does in this opinion, joined by Chief Justice Roberts, another conservative appointee to the court, is say we're going to exclude all normative considerations and we're just going to interpret the meaning of the word, which is a conservative, it's referred to as textualism. It's a conservative reading of the law. On the other hand,
a more literal reading, right?
That's what literal, yes, right. Which the other conservatives are unhappy with. They call it a kind of wooden literalism that they think is unwarranted. So I think what you see in in the conservatives who joined the majority is their understanding of the judicial role is similar to the other conservatives, very restrained, not a legislator, more like an umpire, as Chief Justice Roberts characterized it back in his confirmation hearings. But at the same time, when you're calling balls and strikes as an umpire in a game or as a referee officiating the rules of the game, it doesn't really matter whether the ruling goes in favor of the team you like or the team you don't like, right? So for the two conservatives who joined the majority, I think their understanding of the law is just as conservative. In fact, you could even argue more conservative than the conservatives who are dissenting. So really, you have this battle between judicial conservatives over the meaning of what it really means to be a judge.
For our listeners just joining in, I want to remind you of who we're with today. I am joined by Long Beach State poli-sci professor Jason Whitehead, who is also the author of Judging Judges, and we're discussing today's Supreme Court decision over LGBTQ rights in the workplace. To play off of your previous point, let's get into the dissent. Alito was very clearly angry and almost seemed to direct his anger in the dissent specifically towards Robert and Gorsuch. Can you break down Alito's dissent and why he ultimately didn't go with what could be read as a very conservative opinion?
Mm-hmm. Yeah, I think that Alito has an understanding of the judicial role that's slightly different. His understanding of the judicial role is basically that it's the job of a judge to enact the original meaning of the words and not just the words as they appear on the page, right? So like you've got, say, the Equal Protection Clause of the US Constitution, which was enacted back in 1868. It's not the job of a judge, according to Justice Alito and the other conservative justices, to say what we think equal protection means right now. It's our job to look back into history and say what the framers of the Equal Protection Clause thought equality meant. So similarly here, Justice Alito says, when you go back and look at what the word sex meant to the people who voted for it in 1964, he doesn't think any of them had in mind transgender individuals. He's probably right about that. He doesn't think any of them had in mind gay and lesbian individuals. He may or may not be right about that. There's some debate about the extent to which people were relying on the '64 Civil Rights Act to protect gays and lesbians. But even if he's right, even if no one had ever considered protecting these individuals under the civil rights law, that's an understanding of, it's an originalist understanding of what it means to interpret law, which requires judges sometimes to change the language from what we're used to now to what people were used to historically. Whereas the conservative members, Roberts and Gorsuch, who joined the majority, are sticking with a kind of present day understanding of the word sex.
I think this kind of reflects like a conversation that goes far outside law. I mean, I think literature authors, opinion writers at newspapers, that's not what I meant. And there's this kind of, idea that an author has the right to their words, while some argue it doesn't matter who wrote it. The way the words came out can be interpreted as such and should. Is this where Kavanaugh comes in? So Kavanaugh, I felt, was so different from Alito. Alito was clearly angry. Kavanaugh actually applauded, quote unquote, the decision in the sense that it furthers rights for gay Americans, which he said it's a great day in that sense. He dissented, however, he said, because he feels that the court should not legislate. That is the job of Congress. In my very layman interpretation, I read that as Congress needs to insert specific definitions of words if those words need to be updated, and the court should stick to how the law was originally intended to be defined. Would you say that that's correct? And is that a common division between conservative justices and liberal justices?
Yes, it is. And in fact, Justice Scalia, the late Justice Antonin Scalia, was one who made this point over and over again in especially his dissenting opinions against liberal outcomes. And you see some battling over like the legacy of Scalia in these warring conservative opinions here. but yes, I think that ultimately Justice Kavanaugh, his position is that he reviews a number of times when Congress was presented with the option of including LGBTQ Americans under the protections of the '64 Civil Rights Act. And Congress just didn't have the votes to do it. They rejected it a number of times. So Kavanaugh says basically, if Congress said one thing, they said, no discrimination on the basis of sex, and then they were presented with options later on that would have interpreted that language as including LGBTQ Americans, and they rejected it, then that's sort of, to use your analogy, it's sort of like an author, people are interpreting a novel that the author wrote, and the author keeps insisting, no, I don't mean that the character is this way, you guys are interpreting it the wrong way. The problem, however, is that you don't have a single author when you've got legislation, right? You've got a bunch of people voting on things for all kinds of different reasons, and then you've got different Congresses coming in every couple of years, right? You've got new members of Congress coming in, old members getting booted out and retiring. And so can you say that Congress has a will, that the people's representatives in Congress have an intent in a case like this? It's hard to figure out what that intent would be. It's much easier, as Gorsuch and Roberts do, to say the only thing that is really law is the words on the page. In a democratic society, right, our representatives vote for laws that are going to govern us going forward from there. And what are they legislating? Are they legislating their intent? They can't be legislating their intent, because how are we going to know that? The only way we can know it is with the words they use. So this battle that Kavanaugh wants to say, that to be a conservative is to protect the intent of the people who wrote the law. And that's a Scalia position. That's traditional understanding, kind of Federalist Society understanding of.
We don't let a law writer's lack of imagination reinterpret anything they've written, is what you're saying. So if they didn't say they wanted the law to be for a certain population, in Scalia and Kavanaugh's eyes and Alito's eyes, it's not for them.
That's right. That's right.
Now, I mean, of course, I live in Long Beach. I'm a gay man myself, so this issue is obviously personal to me. But this idea that language itself is static, that it doesn't morph, almost kind of worries me. That the idea that legal words remain stuck in their time. Is there any type of argument that in and of itself is kind of dangerous if we keep a language held within a specific time frame instead of keeping up with what society generally refers to in words as they redefine themselves?
Sure. And I think everybody, conservatives and liberals on the court, would agree with you that words cannot remain static if you want to have an evolving society that deals with new problems, that deals with new issues that might arise. Where the difference comes, and you see this very clearly in Kavanaugh's opinion, is who gets to make the change. It's an institutional argument about who's in a proper position to be able to evolve the language of legal protection. And in many conservatives' eyes, the institution that is best suited to do that is Congress and not the courts. But when Congress has already spoken and has spoken very clearly, then according to the other wing of conservatism, it's the job of judges to enforce what the Congress has written. They've already done their job, right? They've already weighed in and said what we should do about a current problem. Now it's the job of a judge to enforce their will, or enforce the language that they wrote.
I would like to segue into the implications of this decision. One of our readers asked, does this affect in any way Trump's decision to block transgender people from healthcare, from the military, etc.? Does he still have the power to enact such decisions, or does this make those things unconstitutional?
It's always hard to prognosticate how a ruling in one case could affect the ruling in another case, because every case is different, facts are different, arguments are different, and so it's a difficult thing to do. But I would say that there is language especially in Justice Alito's opinion, that explains how this ruling could have major implications. At the end of his opinion, he goes on for several pages about the way in which this ruling could affect other sorts of instances where transgender and gay and lesbian individuals are being discriminated against, or at least there's an argument about discrimination. And I think his logic is fairly good on that, that the logic of today's majority opinion could very well be interpreted to use your examples, to prohibit President Trump from excluding transgender individuals in various circumstances. The difference, I think, is that in the case of President Trump's decisions, you sometimes have an executive power angle that counteracts the civil rights angle. So, for example, when the president is acting under his authority as commander-in-chief of the military, there may or may not, it just depends on how you interpret that power, there may be a reason for conservatives to give him more leeway than you would have with a private employer, for example, because of his role in national security issues. And speaking of that, the conservatives on the court have been fairly unified with regard to executive power. And we've got executive power decisions that are going to be handed down soon, within the next month, by the Supreme Court. So it'll be interesting to see whether the conservatives come back together on the issue of executive power, and then whether or not that may stunt kind of the growth of the logic of this case into other areas. It's possible.
Now, outside of Trump's seemingly compulsive decision sometimes to wield that power, what about any contingencies that will move forward to manipulate the decision, a la the current stance to alter Roe v. Wade? Do you think there's already in the plans and in the works groups who are going to try to, obviously not overthrow, but reinterpret this decision?
As it relates to Roe versus Wade?
No, just like the idea that a Supreme Court decision can be not, I don't want to say unsettled, but can be reinterpreted if another case comes about that forces them to re-examine an old decision. Do you think there's a force moving forward that will do that with this? Or
I think so. I think that's just sort of it's endemic to the law, especially to Supreme Court decision making, that you're going to have newer cases coming along on religious freedom, on religious exemptions, but you're also going to have new cases coming along with regard to people raising issues about whether they're protected outside of the employment context. So I think it's more about the facts of different cases that will come to the court, and whether or not the same logic that the court is using with regard to employment decisions would extend, for example, to decisions about students using the bathroom of their choice for the gender of their choice, for example, or people being subjected to admission to higher education, whether they can be discriminated against there by conservative institutions, for example. Yes, so to answer your question, yes, I do think that it will be reinterpreted. It will morph into a direction that it's hard to anticipate right now. But given the composition of the court, I think that you're going to see this split between conservatives more and more often. So the real question is whether or not Gorsuch and especially Roberts continue to vote with the liberal bloc on those issues, or whether they think, yeah, we gave them as much as we could, and now we're going to pull back and not extend the same logic to other cases. Because partly it's a legacy issue for conservatives. Do you want to be known as a conservative, or do you want to be known as somebody who compromised with the liberals on the court?
I want to return to your point about religious freedoms, because I think this is it's a common concern from a lot of people about their religious rights being restricted or prohibited or violated because of decisions such as this. The one thing and maybe you can, because I'm not as eloquent in legal terms, but there's a difference, first of all, between an employee of the government having to enforce certain things versus a private employee of a private company. Can you, for one, distinguish that for people so that they understand the difference between someone feeling they can't issue a marriage license because of a religious violation versus someone denying hiring someone in a private institution?
Mhm. So when it comes to a government employee, or it's anyone acting on behalf of government, they are governed by provisions of the various provisions of the Constitution that forbid them from treating people unequally. When you're dealing with a private individual, the Constitution doesn't extend to private actions, which is why the '64 Civil Rights Act is so important. Congress can legislate rules for private actors, like employers, for example, but government actors are covered by the U.S. Constitution. So there is a difference there. With regard to religious freedom, yes. So you get into issues, for example, on marriage licenses. Let's say remember the controversy with the clerk in Kentucky, I believe, who refused to issue marriage licenses on the grounds of her religious objections. Well, it depends on whether you're seeing her as a government employee, and if you are, and she was a government employee, so if you're seeing that as a government action, then it might very well violate the First Amendment's Establishment Clause. It says that that Congress can't basically establish a national religion or prefer one religion or another, or prefer religion to no religion. So as a government employee, when she refuses to issue the marriage license, you could say that violates the First Amendment's Establishment Clause. On the other hand, as a private individual, if she in her private life distinguishes between friends or between potential spouses, or on the basis of whether they support gay rights or not, that's perfectly within her own private liberty to do, but she's not at liberty to do that as a representative of the government. Am I answering your question about that?
Yeah. And so how does this decision extend beyond those government workers where, a government worker, your religious beliefs are put second to your job because of whom you work for? How does this decision affect people with religious beliefs that they feel might be violated on the private side, or does it at
Mhm.
all?
I think it does primarily because Justice Gorsuch, in his majority opinion, inserted some language that tried to head off that controversy by saying none of these cases involves a religious justification, or at least one of them did in the early stages, but it eventually fell out of the case. And so Gorsuch basically said this ruling doesn't have any implications for churches or for religious organizations or religious individuals. So that kind of opens the door. Well, I mean, the door was already open. I think there have been a number of religious exemption cases going back, 10, 15 years. So those cases will continue to go on, and it might very well be the case. I think it probably will be the case that Justice Gorsuch, at least, we'll see about Chief Justice Roberts, will vote with his conservative Confederates on the court on the issue of whether religious individuals can exempt themselves from those civil rights laws. He did vote with them in other cases, including the Hobby Lobby case and the Masterpiece Cake Shop case, which may be signs of the future in terms of private individuals being able to exempt themselves from the rules.
But before we end this conversation, are there any pending cases coming up that will be either deeply connected or be influenced by the decision made today? I know you said that we're going to be hearing a lot about in our private conversation about religious liberties. Could you elaborate on any of those and what the implications are?
Mm-hmm. So there are a number of cases involving that are being brought by groups like the Alliance Defending Freedom and other Christian conservative legal organizations that are representing plaintiffs who feel that they have been discriminated against based on their First Amendment rights to practice their religion because they own businesses that are covered by state level or federal level civil rights laws, and they feel like they may not want to. The Jack Phillip case is a great example of this, who doesn't want to serve gay and lesbian couples who are getting married and want a cake to commemorate that wedding. His religious objection to same-sex marriage leads him to say that he will not bake a cake for that purpose. So those kinds of cases, are they affected by today's ruling? I think they are, in the sense that now we know that federal civil rights laws apply in that context. It's not an employment context, but we at least know that we can interpret the word sex in that context And we may be able to interpret that same word in the context of public accommodation and serving people without regard to race, creed, sexual orientation, gender identity. But as I said, now you've got a conflicting right at issue. You've got the rights of LGBTQ individuals on the one hand, but you've also got religious freedom, which is protected by the US Constitution. And when those clash, I think that, again, I think the conservatives will come home. They will vote as a bloc to support the religious objectors. On the case, there's another case from Connecticut involving sports, as we were talking about before we went on, involving individuals who were born male but identify now as female, who are competing in female sports, in track and field in particular, and winning a lot of awards. And the female athletes are, I'm sorry, they're both female athletes. The athletes who are born biological females are bringing a lawsuit arguing that their right, which is protected under federal law, to compete on an equal basis with men in sports is being denied them because biological men are competing in their sport. So it basically denies them gender equality. Those kinds of cases could be very interesting, because then what's happening is you're pitting gender equality between men and women against gender identity equality. And that gets really tricky. Again, I think the conservatives are probably gonna, if we get a case on that kind of issue, the conservatives probably vote against transgender rights in that context. But that's just a prediction.
Do you then think that liberal contingencies will try to refine or revolve their cases around this pivot that happened between this conservative swing and appeal to Gorsuch's and Roberts' lenience that if you can get it back to that basis of that one word sex, they'll go with it? Do you think that maybe liberal organizations fighting for these things will begin to pivot their own arguments in order to appeal to that?
Oh, absolutely. No question about it. If I'm arguing a case before the Supreme Court, I'm looking very carefully at this division between the conservatives. And one way to divide them, to continue to divide them against one another, is to begin making arguments that are based more on a kind of textualist interpretation of law, rather than a reversion to an older understanding of originalism. So without getting too academic about the debates between conservatives, if you want to bring Kennedy, I keep saying Kennedy, if you want to bring Roberts onto your side and Gorsuch onto your side, it looks like they're much more willing to accept arguments that don't require them to go back to a historical understanding, that simply require them to read the language itself, because it seems less subjective. It seems more they can make the argument that they're just right down the middle of the road.
Seems far more literal.
Yeah, well, yes, exactly. More literal and less conservative. It doesn't look as conservative, right? Because it just looks like, yeah, just reading the language.
Well, I want to thank you for your time today, Professor Whitehead. For those who want to learn more about Professor Whitehead's academic work and his research in this field, again, Judging Judges, it's available on Amazon and pretty much any major bookstore. Check it out. I thank you again. For all our listeners, as always, every weekday at 1 p.m. are our live chats. I thank you for spending time with me, and I thank you again, Professor. What you did and what you said was really enlightening.
Thank you for having me.